Bail application 4625/2023.
Petition dismissed.
Criminal petition 101/2024.
हो गया सर तो बोले तो हो गया सर any mention
Yes. May previous lordship, my lord, I pray for listening this matter Wednesday, my lord, bail application, my lord, regular bail application.
when
Wednesday, my lord, obliged.
May it please your lordship. My lordship, I beg to mention for listing of an anticipatory bail, your lordship, for tomorrow, my lord. The matter
tomorrow
is already.
tomorrow may not be possible
In that case.
on
day after
Wednesday we may try.
Wednesday, my lord.
Deeply obliged.
May I please, your lordship, for listing of the IA lordship in a bail application, can it be on Wednesday, lordship?
Wednesday
Wednesday.
okay
Obliged. May I please lordship, listing of IA criminal in IA criminal appeal. Listing on Friday, my lord.
Friday may not be possible next Monday
Next
Monday.
Monday.
May I please, your lordship, I beg to mention one criminal petition, my lord, for listing on 13, my lord, kindly, my lord, allow, my lord, on 14, my lord, it is fixed on, my lord, fixed in the, my lord, trial court, my lord.
13 may not be possible
14, my lord, trial court, my lord, it is fixed,
on 14 we will try
my lord. I love this.
May I please, your lordship, lordship, beg to mention item 27 and 29, lordship. CD is not available, lordship.
27 29
Lordship.
so Sharma when
My lord is from Nagaon.
27 and 29
27? What is going? My lord here. Forest will appear, my lord. Anyway, let's see.
CD not available
Not available.
okay on the pair being made by Mr.
Arakta lordship.
Actor learned counsel for the applicant list the matter on when
Next week. lordship.
22nd 2/2.
on that day learned additional PP shall produce the case before this court
Deeply obliged. Lordship, I pray for listing a quashing petition tomorrow, lordship. The matter
Tomorrow
is
not
fixed-
possible.
The matter is fixed tomorrow, lordship, in the line trial court.
maybe
Honestly,
who is responsible for delayed filing of the petition
Lordship, filing was done before, but there is no stay, lordship.
no
Stay was to be considered.
on Thursday we'll try
Obliged, lordship.
May I please, your lordship, I beg to mention item number 37 of today's part 1 with the concern of the other side. lordship. There was called for.
37.
37
37. We are on interim bid.
okay on the pair being made by Mr. S. Soikia learned counsel for the applicant list the matter on
27 March.
on that day learned additional PP
Fine.
shall produce the case before this court until next date interim order passed earlier shall continue
Deeply obliged.
Like to mention listing of criminal petition 548 of 23. My lord, it was been last posted only in 26/7/23.
when do you want
I want it to be listed by tomorrow or day after.
tomorrow may not be possible on Wednesday also a lot of matters have been fixed your matter may not reach on that day
Monday
on Thursday
18th.
we'll try Thursday
Please, lordship, I'm praying for listing of the criminal petition of lordship.
when
Can it be on the next week, any date in the next week? lordship?
take a date from him
Deeply obliged.
22nd March.
Mr. Lordship, I beg to mention for listing of criminal revision 383/2020.
when
15/3.
15 possible 15 1 okay
May I please, your lordship? Lordship, I am praying for a new listing for motion, my lord, bail application, my lord. Lordship, the case there is already with the office of the public prosecutor, my lord, because the main accused lordship is already.
When do you want?
Tomorrow if possible,
Not
because
possible.
otherwise they may return the case there, my lord.
No, no, you request them to retain the same.
Then day after tomorrow, my lord.
Oh, no, Thursday we'll try.
Thursday.
Please, your worship, this is regarding listing of IA criminal number 1129 2023.
When?
Day after tomorrow, your worship.
Day after?
Tomorrow.
Day after tomorrow, already a lot of matters have been.
I think your worship, day after tomorrow it can be done.
On Thursday we'll try.
Thursday, your worship, this will be led by my senior, your worship. My senior won't be there, your worship.
That is your problem, not my problem.
Please, your worship.
My pleasure, lordship. I'm praying for a listing for bail application for withdrawal, lordship.
When?
Tomorrow, lordship.
May I please, lordship? My lord, I'm praying for listing of a case, my lord. Only it can be listed Friday, my lord.
When?
Friday, my lord, 15/3.
Friday.
my lord.
Possible Friday. 1. Okay.
Oblas.
May it please your lordship, I beg to mention for listing of a criminal revision petition
When?
for withdrawal
When?
tomorrow.
Tomorrow.
Public.
Your worship, instead of Thursday, can it be done after 17, your worship? After 17.
Okay. Any date you can take from him after 17.
22.
Yeah, please, your worship. I have actually item at 31. Is there was called for minus, but has not been received. 31 CD note.
On the pair being made by Mr. A. Soduri, Mr. Bora, learned counsel appearing on behalf of Mr. A. Soduri. Recessal is the matter on.
Can be on 22nd.
22nd.
Yes,
Okay.
ma'am.
On that day, learned additional PTCL produced the case before this court. Are you on interim?
Interim.
Till then, interim order shall convert.
Give your.
Motion BA matter. Item number 1.
May I please, your lordship? May I please, your lordship?
Yes.
Lordship, the accused is charged under lordship 380 and 411 of IPC lordship. Where 380 does not, section 380 is not attracted lordship. And in regard to section 411 lordship, the accused is, the petitioner is only the buyer of the scrap materials lordship, and he has also the registered certificate from the Gabura lordship.
Registered certificate from Gambura.
Yes, lordship.
Whether Gambura can issue such certificate?
Lordship.
Hmm?
In Annexure 4 lordship and Annexure 5, copy of the license and copy of the certificate of registration we can see, lordship.
Yes, madam.
He might be a valid proprietor of that scrap business. He might be dealing it properly, but the stolen articles were found at his place. Again, of course, the intention will come, whether he knew that those were stolen articles. But fact is that stolen articles were found from his place, it was recovered. Only that we need the CD to see whether he had the knowledge that those were stolen articles. Otherwise, he being a scrap dealer is not, he cannot be disputed, I think, from section certificate of registration passed under 3C of Assam Panchayati Raj Act.
Okay, CD on
Lordship, this is
Wednesday.
Bongaigaon. So,
Wednesday?
let it come up on 18th then, Monday,
Next Monday.
next Monday,
It will
My
take
lordship.
too long, no?
Bongaigaon.
There is more than 1 month in jail, Azad.
Yes, lordship.
Yes, sir.
So Friday.
So Friday, Lordship, then it is 15th, Lordship. 15th.
Obliged.
May it please, my lord. 438 application, my lord. Allegation against me, my lord, 420, 406 and 34, my lord. Punishment is 7 years, my lord. My lord, as per my lord, Anish Kumar, my lord, 41A notice, my lord, should be, my lord, furnished to me, my lord. Without furnished, my lord, 41A notice, my lord, they have arrested me, my lord. My lord, allegation is, my lord, one fake gold, my lord, possessed, seized from me, my lord. The allegation.
Gold. It's
Yes,
the
fake gold.
business of fake gold, and he was carrying one boat. Small boat. It is a
Yes.
semi boat, shape of a semi boat. As far as he is concerned, the allegation is only that it was recovered,
Yes.
that fake gold. Money and all were in relation to other people. But they were cheating the localities, the people of the localities.
Is there any allegation?
But he will
You know,
be
why this 41A is not complied with?
41A क्यों comply होना है?
Yes, my lord, they have taken ground that I am non-local resident, my lord. It is not a ground, my lord. A forwarding report, my lord. Page 14, my lord.
It's written 41A could not be applied for the accused individuals since they are not non-local resident. There is no likelihood of their cooperation. That of course cannot be a ground.
Madam, you obtain instruction and apprise this court at 2 p.m. whether this 41A is complied with or not.
No, not complied. It's written here because they could not, because he was a non-local. It was the procedure.
No,
was not-
is it a just ground
No, it
for
cannot be,
not
in fact.
complying with?
But then the further instruction, they'll say they have not done it because of this reason.
Not a valid ground.
That depends on the facts, but
Hmm? So what to do?
he was inside since 22. Not very long also, 22nd of February. This is 420 and 406 only. Leave it to your lordship.
Heard, Mr.
M. Kolika.
Learned counsel for the accused and also heard Ms. Zahan, learned additional PP for the state respondent. This application under section 439 chapter 6 referred by accused. Mohammad Riazul Islam alias Riazul Islam, who has been languishing in jail in connection with Agia PS case number 16 of 2024 under section 420 406 34 IPC. Since 22 to 2024 for grant of bail. Is to be noted here that above noted case has been registered on the basis of an FIR lodged by SI Rubsuti Kolita on 21 to 2024. The essence of allegation made in the FIR dated so and so is that in connection with Agia PSGD entry number 8 of 28 dated 21 to 2024, the informant along with staffs proceeded to Sanmari area and apprehended one Riazul Islam, who was in the custody of the local people, with one boat of suspected gold weighing 1181 grams and seized the same in presence of witnesses, and also apprehended another person, namely Abodhesh Kumar Ahirwar, and recovered 16,500 rupees from him. And during interrogation, they reveals that one Fuluddin Sheikh is also involved with them in the business of fake gold. And thereafter conducted search in his house and recovered one school bag with 7,390 rupees and seized the same in presence of witnesses. Mr. Coletta, learned counsel for the accused, submits that the accused was arrested on 21/2/2024 and since then he has been languishing in jail. Referring to the forwarding report at page number 14, Annexure 2 of the petition, Mr. Coletta submits that while causing arrest of the accused, the IO has not complied with the provision of Section 41A CRPC, which is mandatory in view of compliance of which is mandatory in view of judgment of Honorable Supreme Court in the case of Satinder Kumar Antil versus CBI. And therefore, Mr. Coletta submits that the accused may be enlarged on bail. On the other hand, Ms. Jahan, learned additional PP, also submits that the ground assigned by the IO for non-compliance of Section 41A CRPC is not at all tenable. It is to be noted here that in the case of Satinder Kumar Antil versus CBI, within brackets, Honorable Supreme Court has held that while causing arrest of the accused, Section 41A notice has to be served upon the accused, and non-compliance of the same will be a ground for enlarging the accused on bail. In the case in hand, admittedly, the provision of Section 41A has not been complied with. Therefore, this court is inclined to allow this petition. It is provided that on furnishing a bond of rupees 50,000 with 1 unit of like amount to the satisfaction of the learned Chief Judicial Magistrate Goalpara, the accused be enlarged on bail.
Item number 3.
The 482 application against the judgment of the learned appellate court where the maintenance award in a DB case was set aside, my lord. So the petitioner had filed 2 cases, my lord, one MR case and one DB case, my lord. In the MR case, maintenance of rupees 8,000 was awarded, and in the DB case, my lord, maintenance of 5,000 was awarded for the petitioner and her minor son. So the respondent, my lord, filed an appeal against the maintenance award in the DB case, which was set aside, my lord. We're challenging that order, my lord. So at this case, my lord, notice may go to the respondent.
Okay, heard Mr. S. Nawaz, learned counsel for the petitioner, and also heard Ms. Jahan, learned.
The DV case, my lord, state is not a party. It's a DV case, my lord, state is not a party.
State is not a party.
DV case.
So in this petition under Section 482 CRPC, the petitioner, namely Musammat Rupali Begum alias Rupali Begum, has challenged the correctness or otherwise of the judgment and order dated 30/9/2023, passed by the learned additional session judge number 2, Nagaon in criminal appeal number 13 of 2022. It is to be noted here that by impugned judgment and order dated so and so, the learned court below has set aside the final order dated 25/4/2022, passed by the learned judicial magistrate first class Nagaon in DB case number 432 of 2015. Qua payment of monthly maintenance at the rate of rupees 5,000 to the petitioner and her minor son from the date of application. Peruse the petition and the documents placed on record. Let notice be issued to the respondent returnable in 4 weeks. Step be taken by registered post and also by usual process within a week from today. A call for the record from the learned court below. No, recessal call for the record from the learned court below. List the matter for 4 weeks.
Deeply okay. Item number 4.
May I please, your lordship? My lord, this matter, lordship, I have challenges the order dated 8/1/2024 passed by the learned CJM Khachar, lordship. By which lordship, the CJM Khachar reviewed the order of the learned JMFC Khachar, lordship. Lordship, the facts of the case is that, lordship, some 2,040 bags of betel nuts were seized from the lordship custody of the petitioner's house of the petitioner's father, as well as his uncle and his brother-in-law, lordship. by the Dholai police in the year 2022, Lordship, February 2022, Lordship. Thereafter, Lordship, petitioner filed a Jimma
So
petition.
the CJM has rejected your pair.
Yes.
Lordship, initially I have filed,
No, you answer my question. CJM has rejected your
not
pair.
rejected, Lordship, modified the order of the learned JMFC, Lordship, by which Jimma was given to me, Lordship. Even,
Can the CJM modify the order?
yes, Lordship, CJM modified the order. That, Lordship, your Lordship may kindly, Lordship, come to Lordship.
Where is the original order passed by the magistrate?
Yes, Lordship, the magistrate order, Lordship. There are two orders, Lordship. After remanding the case, Lordship, by this honorable court, Lordship, I have filed one Jimma petition before the learned CJM, Lordship, which was transferred to the JMFC, and at page 104, Lordship, that initial order, Lordship, 31/7/2023, Lord.
Yes, by
104.
this order, learned judicial magistrate has allowed your pair.
Allowed my pair, Lord.
Acha,
Thereafter,
seeking
that was
custody of 2000
40 bags of betel nuts.
betel nut. Thereafter,
Thereafter, that was not complied, Lordship.
who,
Then,
com-
Lordship, I have
who had not complied?
by IO, Lordship.
IO.
Yes, Lordship.
Thereafter,
Thereafter, Lordship, I have submitted one as per SOP, Lordship, that betel nuts has to be used for industrial purpose, Lordship.
yes.
So I have submitted one willingness letter from one JGM Industries, Lordship, who used those products. At page 107 is willingness letter issued by the JGM Industries, Lordship, which was already verified by Hailakandi Police, Lordship, and similar nature of goods, Lordship, already released, Lordship. So, but thereafter, Lordship, I have submitted one again petition, Lordship, against the Lordship CJM. Then, Lordship, 7/9/2023, 114 order, page, Lordship, 114 page, Lordship. Again, there is no information regarding any revision of order dated so and so filed by the prosecution. IO is therefore directed to comply with court order and hand over the betel nuts to the petitioner as per terms of order dated so and thereafter file a compliance report. Petitioner is directed to go to the PS within a week from today to receive the Jimma of betel nuts. Then, Lordship, petitioner go to the PS, but that was also not handed over. Again, Lordship, petitioner, the date was fixed on 16/9, Lordship. Then on 16/9/2023, Lordship, the IO filed a petition before the Lordship, jurisdictional magistrate, Lordship, saying the Lordship inability to hand over the goods on Jimma, Lordship. And again on 16/9/2023, Lordship, page 118, 118, Lordship, the observation given by the learned jurisdictional magistrate, Lordship, that IO has no authority to decide the correctness of the order of a judicial court. The implication of the order has already been got by the court, and hence necessary condition has been imposed upon the petitioner for receiving the Jimma of the goods. Next page, Lordship, IO of the case is duty bound to follow court orders, whether in his opinion the order is correct or not. Hence, the reason mentioned in today's report is not acceptable. IO is directed to comply with the Jimma order passed by this court and to hand over the Jimma of the Arakaners to the petitioner within 15 days from today. That was also not followed, Lordship. Then again, I filed a petition before the CJM, and in the meantime, Lordship, CJM had taken, now directly CJM had taken the issue, Lordship. And then, Lordship, by the order dated, by the impugned order dated 8/1/2024, Lordship, CJM modified the order.
Page number?
Page number 128. Saying that page 132 is the operating portion, Lordship.
130?
132 is the operating portion, Lordship. Now, CJM is saying that I have not proved my ownership. After 2 years, more than 2 years, Lordship, now CJM modified the order and saying that I have to prove my ownership before the IO comes. And some other conditions also put forward. So, So, Lordship, it is basically contempt of the court by the IO. But that was, Lordship, judicial discipline was not maintained because the Lordship, under the authority of CJM, earlier orders, all the orders were passed, Lordship. Now, he himself modified the order, which is barred by section 360.
No, there was some signs of circumstance. In one criminal petition, division bench has given some
Yes, that.
observation, and
that-
because of that, the
Ah.
CJM has modified the order.
And that judgment was of 7/23. And the magistrate's order was after 2 months. And the
After 2
division
months of?
bench, 2 months of the division bench order. And the division bench order was not followed because police cannot give articles in Jimma during investigation under 451.
No, Lordship.
This is clarified by the CJM.
But 457, Lordship, the CJM, the jurisdictional magistrate can grant Jimma, Lordship, as per observation of this honorable.
Okay, at this stage, we will issue notice.
Lordship, at this
Let the
stage,
record come.
Lordship, may I pray one thing, Lordship? Because, Lordship, the industrial buyer, because more than 2 years already kept those battalions, Lordship, and even now, Lordship, the industrial value also, Lordship, deteriorated. So at this stage,
We will
Lordship,
fix a very short date.
Short date, Lordship, yes.
Let the record come. Heard, Mr.
NH 4
N.S. Borboya, learned counsel for the petitioner, and Mrs. Zahan, learned additional PP for the state respondent. Correctness or otherwise of the order dated 8/1/2024 is challenged in this petition under section 42 surface by the petitioner, namely Anwar Hussain Loskar. It is to be noted here that by the impugn order dated 8/1/2024, the learned Chief Judicial Magistrate Kasar Silsor has modified the order passed by the learned Judicial Magistrate First Class dated 30/7/2023 in Dholai PS case number 49 of 2022 and 7/9/2023 and 16/9/2023. Whereas the petition and the documents placed on record, let notice be issued to the respondent returnable in 4 weeks or short date.
Lordship, yes.
Short date.
Within
Lordship, short date may kindly be given because there are no private respondents. So 2 weeks is enough.
2 weeks. Okay, 2 weeks. Returnable in 2 weeks. Submit taken upon respondent number. No, there is no respondent except the state. No formal notice is required to be issued since Ms. Zahan learned additional PT appears and received notice. However, extra requisite copy of the petition be furnished to her during the course of the day. Rest shall call for the scanned copy of the record from the learned court below. List the matter on fixed date.
26,
27th,
27.
27th of March.
Obliged.
Case diary, no? Case diary, no?
Item number 5.
Oh, the case diary.
Lordship 438 application, my lord. Earlier, my lord, last occasion, my lord, instruction was sought for. My lord, allegation is that the petitioner so illegally lent money to local people, but no FIR has been registered. That's why, my lord, the
Acha, acha.
instruction.
Yes,
was
Madam, have you?
I can take it up at 2 because we don't have the information now.
Then 230.
2:30. Yes.
Obliged.
Item number 6.
May please, your lordship, as a 438 application, my lord, the lordship will find the FIR at page 18, my lord, 18. My lord. Translated copy, my lord. May I read out?
Yes.
The informant is one, my lord, Lakshmi Saha, my lord. Sir, humble submission is that I hereby inform you that since about 1 month, a group of some unknown persons of Bokajan Ward number 2, Chandrapur under Bokajan PS with some local Asha Kormi of Bokajan and Khotkati area conducted camp at Bokajan and Khotkati area and collected rupees 30 in the name of registration. Rupees 500, 800, 1000 in the name of giving spectacles fraudulently. They have done this without obtaining permission from the departmental authorities. Therefore, I request you to investigate the matter and take necessary action against the culprit as per law. Now, if I turn to page, my lord, 10, my lord. This organization, my lord, is a non-government organization, my lord. You had a registration certificate that your lordship will find at page 10.
No, that's all right, but can you conduct such a camp
Yes, my lord.
without permission of the
My lord,
health
that's true,
department?
that's true, my lord. My lord, we have made an application that your lordship will find no, it's an application. We have preferred an application, my lord, that your lordship will find at page 35, my lord, Annex 8, my lord.
35.
35, my lord, Annex 8.
Whether permission was granted to you?
My lord, verbally we have been informed, my lord, by written, my lord, to be honest, my lord, no permission was accorded, my lord.
No, can
And my lord-
verbally permission
And in fact, my lord,
be
in other
granted?
district also, my lord, we have conducted the same, my lord, that your lord.
Where?
Other districts, my lord, that your lordship will find, my lord, at page, my lord, page 30, my lord, 30 onwards, my lord.
No, maybe you may conduct in other districts also, but without permission of the authority, can you conduct such a camp?
There is no fraudulent on our part, to be honest, my lord. Actually, we applied, my lord, for written permission. We have
No,
not obtained.
without a written permission, how can you?
Now, my lord, from page 36 onwards, my lord, the 41A notice has been served upon us.
So, madam, what is your view?
I will appear before the.
In fact, no permission, as your lordship said, and page number 30, what he is referring, that is a permission granted in respect of other areas.
Other areas.
But then in this area, there was no permission. Without permission, they did. 41A notices are giving. Let them go and appear. Raise the apprehension. And this is 420, 406 only.
Heard Mr. N.J. Dotto, learned counsel for the applicant, and also heard Ms. S. Zahan, learned additional PT for the state respondent. Apprehending arrest in connection with Bokajan PS case number 10 of 2024 under section 420 406 IPC. This application under section 438 CRPC is preferred by 9 applicants, namely so and so and so. It is to be noted here that a noted case has been registered on the basis of one FIR lodged by one. Page number FIR?
My lord, page 18, my lord, 18, my lord.
Lodged by one Lakshmi Saha on 23rd to 2024. Presence of allegation made in the FIR dated so and so is that. Since 1 month, a group of unknown persons at Bokajan Ward number 2 at Sandopur under Bokajan PS with some local Asa Kormis of Bokajan and Khotkati area conducted camp and collected a sum of rupees 30 in the name of registration and 500, 800, 1000 in the name of giving spectacles fraudulently. And they did so without obtaining permission from the departmental authorities. Mr. Dotto, learned counsel for the applicant, submits that the applicants have received notice under section 41 CRPC and that they have conducted such a camp in other district also, and they have also applied for permission for conducting such camp at Bukazan Kotkoti area. But no written permission has been granted to them, though they have been granted verbal permission. And that they are ready to cooperate with the investigating agency, and therefore it is contended to allow the petition. Whereas Ms. Ezzahan learned additional PP submits that it is apparent that they have conducted the camp without written permission from the authority concerned. And as such, Ms. Jahan has opposed the petition, having heard the submission of nine advocates of both sides. Perusal of the case area is found to be necessary, and accordingly it is provided that case area be called for fixing the matter on. When, madam?
This is Karbi Anglong, no?
2nd April,
So, Lordship,
2nd
March
April.
only, and 20th of March.
And in the interim, considering the submission of learned advocates about the parties and
They're
also
not taking
considering
long
the facts and circumstances on the record, this court is inclined to extend interim protection to the applicant till receipt of the case daily. That is 5,000. No, sorry, 50,000, and without permission of subdivisional judicial magistrate, Bukazant, M. Bukazant.
I'm obliged.
Then that, I'll take a long date since interim is
Okay.
granted. So April, 5th of April.
Lordship.
I'm obliged.
Item number 7.
May I please lordship? 438 bail application. Translated version of the affair is page 13 lordship. The basic allegation against him is that he, the informant and his brother too has taken some from different persons on interest for the treatment of his daughter as well as for the business purposes. And later on, they have repaid the loan amount as well as the interest. But they have alleged that at the time of taking the loan, some person have forcefully took the blank check as well as some land documents. That is the allegation also. The case is raised under section 384 and 420. Lordship may have page number 20. It is a copy of registration certificate. That the info. The petitioner is a registered moneylender, lordship.
Where is the certificate?
At page 20, lordship. It is issued by the registrar of moneylender. And on the basis of the same certificate, lordship, we have granted loan to the informant. And he has admitted that he is indebted a sum of rupees 54 lakhs, lordship. At page 21 to 25, that is the copy of the agreement, lordship. Wherein he has admitted that he has taken a sum of rupees 68 lakhs from the petitioner, and he has repaid a sum of 14 lakhs, but he has still that he liable to pay a sum of rupees 54 lakhs out of 68 lakhs, lordship. And in that,
Who determined this percentage of interest?
you know, yeah, hearing is the percentage is not written, lordship. It is the principal amount. Principal amount is 68 lakhs. Out of he has repaid 14 lakhs, and 54 lakhs is still pending, lordship. And in discharge of his liability, the informant has issued 5 number of checks, lordship. And all the checks are dishonored due to insufficient of funds, and we have filed complaint petition before the CGM Nalbari, lordship. And all these cases are pending at page number 26 to 64, lordship. These are the certified copy of the complaint petition, lordship.
Now, this agreement was of January 23, where it is said that he had to pay so much of amount. But after that, he said that he had paid the amount by selling and all. So the instant FIR is February 24, where it is said he has made the complete payments. There was no occasion for him to harass.
No, lordship. We have filed complaint petition on the month of October, lordship. That is
Let
prior
us
to
do one
lodging
thing.
the affair, lordship.
Madam, you call for the case, I sort that.
But till that lordship, I am protected as because you know, there 5 cases are pending and all these cases are prior to lodging the FIR lordship.
We'll see.
Lordship may have a look at
You have
the,
no business to keep his land document with you.
but this is the only allegation lordship. He may prove you know, if
That's why to ascertain the allegation, we have called for the case there.
Short date will do, Lordship will fix it on 18th of March,
18 March.
18 March.
Okay, 18 March.
Alley of lordship. Item number 8.
Wait. 438 application, my lord. I have stated the reason why I have filed the case. It's the
So there is no FIR.
3, 4, and 5.
From which PS it is?
By the surrey case.
By it as a.
No, 2 days later, the police person has visited.
Okay,
my house.
madam, you obtain inspection,
Lordship,
written
yes.
inspection. We'll fix it tomorrow.
But then what he has written is, no case has been reported to be registered and the
Yes.
petitioner was not aware of the registration. The requirement is that he should be aware that there is an FIR. In that cases, he can move such application.
So far, my lord,
Yes, unless the case has been registered, where is the apprehension?
my
Yes.
lord, I have filed this because of the fact 2 days, my lord, police has visited my house while I was on duty. My lord. I am relying on the my lord principal.
Okay, okay.
CVS case, my lord.
Heard Mr. M.K. Sharma, learned counsel for the applicant, and Ms. Azzahan, learned additional PP for the state respondent. This application under section 438 services preferred by applicant Gautam Dekka, who is not aware of about registration of any FIR with the Bayata Sarali police station, but statedly he is being searched by police for last 2 days.
Since
days.
24. So 26 to 2024. Paragraph 3.
Not necessary. But having heard the submission of learned advocates of both the parties and also considering the facts and circumstances on the record, it is provided that Ms. Zahan, learned additional PP, shall obtain one written report from the officer in search by it as early PS. So whether any case has been registered against the present applicant or not, fixing the matter tomorrow or day after tomorrow.
Not day after tomorrow.
Day after tomorrow. Okay.
Wednesday.
13 March.
All right.
Item number 9.
may I please the lordship? Lordship 438 bail application lordship. Lordship page number FIR at page number 8. Type and translate copy of the file. May I read lordship? May I read lordship?
Paper is at page number
8. I type and translate copy of the file lordship. At page number 8.
This is POXO matter, let the notice go to the victim.
Lordship, actual case is that lordship. There is a misunderstanding happened between the two family petitioner and informant lordship. And accordingly, the petitioner and informant had executed an agreement before notary lordship and Hemaji on 28/2/2024 for settling their dispute peacefully. Lordship, petitioner is an advocate lordship.
heard Mr.
SK Das.
Learned counsel for the applicant and also heard Ms. Zahan, learned additional PP for the state respondent. Apprehending arresting connection with Hemaji PS case number 25 of 2024 under section 376 AB. Struck 511, read with section 8 of the POXO Act. This application under section 438 services prepared by applicant. Election for grant of previous bail. Since the case has been registered under section 8 of the POXO Act, let notice be issued to the respondent number 2 returnable on 10 days.
Then Lordship has fixed it on Because the procedure is that he has to give copy, then registry will give it to us and I will send it to the police. Will take some time.
Hmm.
So 2 weeks,
2 weeks.
27 March.
Huh?
27.
27th March, Lordship.
27, returnable on
Short date may be
27
given,
March.
Lordship. Short date may be given, Lordship. This will be the bail, Lordship. He is apprehension for police.
I can
That-
serve it through, if he gives me a soft copy, I can serve it to the police, but again, that is not prescribed by the High Court. We'll fix it on
Let us
25th.
try, let us try on Wednesday, 28th.
28th,
Yes,
20.
20.
Yes, Lordship, 20.
Hmm.
We'll try.
Returnable on step be taken by registered post with AD and also by usual process and also through the officer insert jurisdictional PS. In the meantime, the learned additional PP shall produce the case diary before this court along with statement of the victim girl recorded under section 164 CPC.
Not.
Obliged, Lord. Item number 10.
My lord, FIR is at page 7 of the. Page 7.
Let the case diary come only the case.
Last 2 line, in future, Lordship, it may cause harm to me, Lordship. That is the APR training. In fact, Lordship, the affair was lost on misunderstanding. Lordship, I have annexed one affidavit, that is page 12, Lordship. 13 is the relevant. He has already sworn an affidavit saying that it was out of misunderstanding. I have made her party, Lordship, in this petition also, Lordship. And the protection may be given, Lordship, I will appear before the ILS. And my statement may also be recorded. As I have already made party the informant, Lordship, as respondent number 2.
You have appeared before the IO.
But not I will appear, Lordship.
When?
If you, Lordship.
No, he will, he said. He will.
Lordship, I will appear.
Oh, you will appear. Acha. So the question is, how far this affidavit is genuine?
That's why, Lordship, I made her party, Lordship, as respondent number 2. Your Lordship may also notice.
Let the notice go as well as the CD come. Her statement was recorded by the police perhaps by now, so she will say about the agreement and all.
Yes, Lordship, that's why, Lordship, regarding genuineness, Lordship, she will come. Lordship, my
Yes,
humble-
let her appear.
My humble submission, Lordship, I may be protected, Lordship.
Heard Mr. M. Khan, learned counsel for the applicant, and also heard Mr. Zan, learned additional PP for the state respondent. Apprehending arrests in Manipur PS case number 26 of 2024 under section 420-406 295A. IPC reads section 66D of the IT Act. This application under section 438 services prepared by applicant Noor Amin alias Nituras for grant of the respect. Having heard the submission of learned advocates of both sides, it is provided that notice be issued to the respondent number 2 by registered post and also by usual process and also through the officer insert jurisdictional PS fixing the matter on this 21st.
CD, Lordship,
Yes.
21st.
On that day, learned additional PP shall produce the case diary before this court, along with statement of the victim woman recorded under section 164 CRPC. No interim.
Item number 11.
Item number 11, Lordship, earlier it was rejected by the Honorable Justice Mijul Kumar Kolika, Lordship. Perhaps, Lordship, it will go to the appropriate page.
Okay. Registry shall list this matter before appropriate court.
Item number 12.
Let's 438 application, substitute case, my lord. cognizance was taken, notice was issued, my lord, as requested, notice may go, my lord.
So POCSO is there,
Yes,
section
POCSO is
4.
I have made a party informant, my lord.
Notices will go now.
Okay.
They are supplying tea lordship in the locality lordship. And subsequently, lordship, dispute arise between the informant and the petitioner regarding some money lordship. And the informant gives some tea to his relative on credit lordship. Subsequently, this amount is not
FIR is at page number?
9 lordships. 9. But the fact is totally different lordship. But I am very clearly mentioned in my petition.
FIR is little dicey, I mean, little what suspicious, because what he said is he met those people in the restaurant, then he met with an accident, he became unconscious. Then the same 2 person had taken him to the hospital, and 9,400 was the bill, I think, and they had actually taken 80,000. I think 80,000 cannot be withdrawn in one single day, perhaps.
Lordship.
30,000 is the limit.
And as per the lordship, yes, lordship, and otherwise lordship, there are one more transaction at a time. And within 24 hours, that cannot be lordship.
Let the case diary come up.
And lordship, and the page number lordship, annexed to page number 16 lordship, and the Hinu Ahmed lordship arrested, and he is the friend of the informant lordship. He is the friend of the informant lordship.
Friend of
This
the
present applicant?
No lordship. And informant lordship. Informant's friend lordship. On that day lordship at the
No, informant is a host friend, this applicant's friend.
lord. No lordship. Informant and the accused another. This is 438 application lordship.
Yes.
And I am not arrested, but lordship another person, and he is the friend of the accused informant, and he is arrested lordship. That because, and if some transaction is done by him lordship, and that mobile is operating by him lordship, and police, that is why arrest him. But the otherwise lordship and the present
No, whether your name is there in the FIR.
It's there. One
Where?
of the suspect's name is Anna Bhai,
lordship.
Ajizul. Not sure, and Anra. Anra is Anna, I think.
Lordship.
Anna.
And they are the same locality lordship. And business and very clear, I have mentioned in my petition lordship. And para number 3 and 4, and the entire fact of the transaction between the petitioner and the informant lordship. I don't let the lordship civil nature, and if there is anything a lordship.
This is actually a cyber crime if he has done it.
Mobile is available lordship. Mobile is operated by his one friend lordship, but not by me lordship. So only for consider for the para number 4 lordship, and that very clearly mentions specifically by environment. And if they have any conspiracy lordship, and for misappropriating the business money, that is up to them lordship. But otherwise lordship, my limited bear lordship, entry protection, and otherwise lordship, if there is anything against me lordship, that I'll face the consequences. Civil nature, otherwise.
So who is your friend?
My informant and me lordship, we are the business partner. And the one accused arrested here, and the Sunmoni Ahmed, he is the friend of the informant lordship. And the page number 60.
Sunmoni Rahman.
Sunmoni
Who
Rahman.
is Sunmoni? Anna Bhai has it?
Sunmoni Rahman lordship. Sorry, Sunmoni Rahman. Case number 17.
So Sunmoni Rahman is a friend of the informant.
Informant.
Yes.
That there is mobile is operating by him, lordship.
Oh, Sunmoni.
Sunmun, not by me, lordship.
And both of you have taken the informant to the hospital.
Lordship. But otherwise, lordship, my part is nothing, lordship. Here. Actually, only their intention is to.
Heard Mr. Adhoc, learned counsel for the applicant, and also heard Mr. Zahn, learned additional PP for the state respondent. Apprehending arrest in connection with Hatigao PS case number 15 of 2024 under section 379 406 IPC. This application under section 438 services prepared by applicant Azizul Ahmed for grant of PSP. The above noted case has been registered on the basis of one FIR lodged by one Aminul Islam on 27/1/2024. The essence of allegation made in the FIR dated so is that on that day, he along with one Kaushik Borua proceeded to a restaurant, the name in style Pizza, for having some food. At about 10:30 p.m. And while he was coming out from the hotel, then he met two persons, namely Amma, Siur and Amma, as who introduced themselves to him as Siur and Amma. And while then on the way he met with an accident and become unconscious, and then he was taken to H&M Hospital, Hatigao. And after treatment, one person known as John Markel asked him to pay a sum of rupees 9,400, which he paid to him. And again, he paid a sum of rupees 1,400 to one Nur Alam Ahmed. And later on, the two guys, namely Siur and Anna, drove him near his house and ran away. And when he checked his GPay, he found that a sum of rupees 80,000 was debited from his account to John Markel without his knowledge. And again, some failed transactions were also found to be made for a sum of rupees 10,000, 10,000 and 9,000. Mr. Hawk, learned counsel for the applicant, submits that the applicant is innocent and no way involved with the offense alleged in the FIR, and that it is Sunmoni Rahman, who is a friend of the informant, operated the mobile of the informant. And he is ready to cooperate with the investigating agency, and therefore it is contented to allow the petition. Whereas Ms. Zahan learned additional PP submits that at this stage the case may be called for. Accordingly, it is provided that case be produced before the spot on. Who is that, madam?
1st April.
1st April.
First of
Lordship.
April. Having regards to the nature of accusation and the punishment prescribed for the same, as well as the submission of learned advocates of both sides, this court is inclined to extend interim protection to the applicant till receipt of the case diary, and accordingly it is provided that 50,000 and Season Kamru payment.
Published, lordship, published.
Item number 17.
Please, Lordship. On 438 bail application, madam. FIR is page 13, madam. The allegation, madam, to issue the fraudulent Aadhaar card. by the fraudulent document submitted. But one Parthopotim Bordoloi Malot in the ID number
Mr. Islam,
similar
you
order-
come to page number 2 of your petition.
Okay.
Malot,
So this is AB.
AB Malot, 438.
So what you have mentioned in this that in the matter of in page number 2?
438 million. Really pushing.
Yes. Illegal and arbitrary arrest.
Where?
You have not been
The
arrested.
petitioner,
Oh, yes.
for illegal and
For
arbitrary-
apprehension of the petitioner for illegal and arbitrary.
I-
Apprehension.
Well, let's change it. Well, already main account already reached on bail.
Which one?
Who is the
Parthopotim?
main accused?
One Parthopotim Bordoloi Malot.
Acha, Parthopotim is released. But
Yeah.
Parthopotim, Salam Ali and others were using using the number of Parthopotim, and they sat in a different station and were doing this, issuing fake cards,
Fake Aadhaar card.
fake Aadhaar cards.
But it-
Parthopotim is otherwise he was given different station. Then they took this one, this office as his, and were doing this.
Based on the biometric mallet on the record of the petition applicant, and that card was prepared. Madam. In this mallet, petitioner have no road map.
Heard Mr. B. Islam, learned counsel for the applicant, and Mr. Zaman, learned additional PP for the stateless one. Therefore, this para number 2 and 3 and 4. Mr. Islam, learned counsel for the applicant submits that this court high order dated 1/3/2024 in AB number 426 of 2024 has already extended the privilege of interim periods bill to the applicant. No, not interim. Already extended the privilege of periods bill to the applicant. And that the present whether their names are there in the FIR.
Mallet,
Names are there
names are there.
with
First,
Parthopotim.
first name is the Parthopotim Bordoloi Mallet.
Yes.
Thereafter, the
Salman
Salam
and
Ali
Hafizur
Hafizur
Rahman.
Rahman have come.
And though their names find mentioned in the FIR, they are not the prime accused of the case, and that they are ready to cooperate with the investigating agency, and therefore it is contented to allow the petition. Yes, madam. Also, do we call for the case hearing?
Fake cards, so let us see. Fake, we're cheating people, in fact. Leave it to your
Whereas
lordship.
Miss Begum learned, no, sorry, Miss Jahan learned additional PP submits that addresses this, only the case hearing may be called for. Later, having heard the submission of learned advocates of both sides, perusal of the case hearing is found to be necessary, and accordingly it is provided that CDB call for fixing the matter on when?
20 March.
Lordship has allowed interim, no. Then lordship will fix a short date, 21 years, 21st of March.
And having regards to the nature and gravity of the offense, as well as the submission of learned advocates of both sides, this court is inclined to extend interim protection to
No,
the
till
applicants
April.
till receipt of the case hearing. Accordingly, it is provided at 50,000 and CJM Morigaon.
We'll take a date in April then.
Oh.
April,
3rd April.
3rd April.
Jagirot. Arresting authority Jagirot.
Yes.
Item number 61.
A report was called for.
Yes.
Lordship will take it up at 2. That report is on its way. It's coming, no?
Okay.
At 2.
Okay.
Yeah.
Item number 62.
I will try it. Oh. No.
Right, this is Lord 438 well application and Lordship will find Lord base 11 is the Lord affair.
So this is also POXO.
Yes, now Lordship kindly
was convicted under 138 of the negotiable instrument Act.
Pardon?
My lord, in this particular case, the private respondent was convicted under section 138 of the negotiable instrument Act. Thereafter, he preferred an appeal. In that appeal, my lord, his appeal was admitted subject to deposition of 20%. But later on, he refused to pay that 20%. So we have filed a petition either to dismiss the case or to vacate this stay. But my prayer has been rejected by the learned appellate court. Against that particular order, I have come. And today is the date perhaps fixed for the filing of the reply from the other side. But other side.
Is
Yes,
here, is
Mr.
here.
Martin.
Right, reply.
You are for the respondent?
Yes, ma'am.
So have you filed a reply?
I will allow to some time.
You want some time?
A reply in a criminal revision is not required. Orally you can submit.
My lord, then
Appeal is pending, my lord. In the meantime, appeal is pending, my lord. He has filed an application for dismiss the appeal, my lord. And learned court will rejected the prayer of the petitioner, my lord. On the ground that there is no any provision to dismiss the appeal. And with the finding of the
So how the impugned order suffers from any illegality or infirmity?
my lord, this is a mandatory provision. And this mandatory provision has to be complied.
Time limit. আছে?
Appeal may be admitted, my lord. It is altogether a different matter, but there is a mandatory provision to deposit 20%, above 20%. But learned appellate court below has imposed a minimum amount of compensation. But now, my lord, if that particular amount is not being paid, then appeal either has to be dismissed or stay has to be vacated. My lord, may kindly.
So is it mandated by the section?
My lord,
Is it the mandate of the section?
yes.
138 says so, but if it is not followed, what will be the effect? That I'm not sure. I'll have to look into.
Then, my lord, may fix this matter on Thursday, my lord. We will be.
Thursday.
Thursday.
Thursday, I'll have also
Yes,
have to
Mr.
look into.
Mr. Ahmed? Okay, as agreed by learned advocates of both the parties, raise this and list the matter on Thursday.
No, Sunday.
Deeply offended.
Item number 19.
Yeah, please, your lordship. Your lordship, I have filed this deputy petition if lordship against the lordship judgment filed by the honorable session judge Monica Amla directed the petitioner lordship.
Volume to
pay
come here,
maintenance
finish
of
all
his
the
lordship.
point.
2,000 per month as a maintenance and the rupees of 20,000 lordship as a compensation under section 22 of the DB Act lordship. The lordship, the respondent lordship is already getting maintenance to rupees lordship 6,000 from the petitioner lordship. And lordship, he is a lordship, PT businessman lordship. And who sells lordship, soybean and handmade paper in Hadar marketplace lordship. He is somehow maintaining his family member lordship.
My lord, respondent not paying the decreased amount, madam, is last 9/11/2018, my lord. Since last 9/11/2018 not paying any maintenance, my lord.
No, lordship, this is totally false, lordship. I have a copy, lordship. Your lordship, then your lordship may kindly fix them with another date, lordship. I need to take instruction from the petitioner, lordship. As per my instruction, lordship, he is regularly paid the maintenance, lordship.
Earlier paid, but no, since 9/11/2018 not paid.
Okay, what is your name, madam?
MRDB, lordship.
Miss Emma Devi, learned counsel for the petitioner. Praise that the matter may be fixed on when?
Next week.
22nd March.
Your lordship may kindly fix on 1st of April, lordship.
First of April.
Yes, lordship.
Okay, so as to enable her to obtain necessary instruction from the petitioner. There is allowed.
Item
This
number,
is a list according.
item number 20 and 21.
Yes, please, your lordship. My lord, I am the respondent number 2, lordship. On last occasion, lordship, this honorable court directed the petitioner to deposit the 20% on or before 11/3, lordship. But that was.
But the other side is absent.
Yes, lordship.
Have you seen the council in the
Lordship,
court?
No, lordship.
I don't even recognize them. L. Vajida, K. Meera, I don't recognize them. Srinivas.
Yes, me found, but I have not seen him. Perhaps he failed to deposit, lordship.
That's why they are absent.
Yes, lord.
Anyway, that question I will go into whether non-payment of 20%, what would be the effect? I've just found that in cases of Bill 389, even if he doesn't pay 20%, that is not an absolute rule, still the case can be heard. So let us see what about the conviction they say.
The concurrent findings. lord.
Okay, none appears for the petitioner on call. How about Mr.
NH Borbuya.
N.S. Borboya, learned counsel for the respondent present. List the matter on when.
Next week, that case is Vikram Simpson. 20 is of
22.
22.
20.
Okay.
All right. Item number 22.
Maybe zero. Appeal against acquittal lordship. Respondent number 2 was acquitted from the charges of section 376 IPC.
So the notice was issued, not issued.
No, first time lordship. And lordship, the appellant is the informant victim lordship.
Heard Mr. N. Hassan, learned counsel for the appellant, and also heard Ms. Ezahan, learned additional PP for the state respondent number.
Lordship can admit it as well. It's a statutory appeal.
For the state respondent number 1. This appeal under section 372 of the Code of Criminal Procedure is referred by Srimati Sangita Das. No, by the victim Srimati X, name withheld. Challenging under section 372 of the Code of Criminal Procedure, challenging the correctness or otherwise of the judgment and order dated 14/9/2023 passed by the learned session judge number 2 FTC Tinsukia in session case number 57 T 2021. This to be noted here that by it impugned judgment and order dated so and so learned the learned additional session judge number 2 FTC Tinsukia has acquitted the respondent number 2 from the charges under section 376 IPC. Peruse the memo of appeal and the grounds mentioned therein, and also peruse the impugned judgment and order dated 14/9/2023. Let notice be issued to the respondent number 2, returnable in 4 weeks. Step be taken by registered post and also by usual process, and also through the officer answer jurisdictional PS. No formal notice is required to be issued to the respondent number 1 since Ms. Zahan learned additional PP appears and received notice. However, extra requisite copy of the petition be furnished to her during the course of the day. This is a call for the record from the learned court below. Leaves the matter after 4 weeks.
Lordship can admit the appeal.
Okay, that admit.
Obligation. Lordship, in this case, we received the affidavit in opposition. We need some time to file a affidavit in reply.
Seeking, why you are not seeing? Let's say, sir, I'm sitting, I have not been informed that it take time. This is very flexible.
Or Mr. your good name?
J. Das.
J. Das, learned counsel for the petitioner, and Mr.
If I could just do. And that's it for the month, like another again. Yeah, there you go. Right.
So your name is here.
Well,
Your name is here.
yes,
This criminal petition number 1340.
yes, madam. I am for the respondent, madam.
You put a respondent.
Yes.
Mr. Sayola, learned senior counsel, assisted by Miss
Yes, sure.
learned counsel for the respondent. Miss Das, learned counsel for the petitioner, submits that he may be granted 2 weeks time. So as to file affidavit in opposition.
Affidavit in reply to the.
No, affidavit in reply. Affidavit in reply. So pair is allowed. Recessal lays the matter on suggested date
27 March.
27 March.
So it's an interim order, your lordship.
Till then interim order pass earlier shall continue.
Madam, by single petition, they wanted to pass 5 complaints.
5.
5 complaints. Single 482 petition, madam.
Is it permissible?
It is not permissible, madam. That is, I have taken the objection also, madam.
Acha, acha. Okay.
Wait, please, Your Lordship. The petitioners were convicted under section 294 and 120B of the Indian Penal Code, Your Lordship, for a period of 3 months. Due to an obscene act, Your Lordship. The judgment starts at page 20. The operative part, Your Lordship.
As a driver of the vehicle. And he failed to produce any document of the said kettle. Mr. Decker, learned counsel for the accused, submits that the accused was arrested on 8/2/2024 and he is behind the bar for last 32 days. And that he is ready to cooperate with the investigating agency, and therefore Mr. Decker contended that the accused may be enlarged on bail. Whereas Mr. R.J. Borua, learned additional PP, has vehemently opposed the petition on the ground that the accused has carried the kettle in the vehicle without any document. And that investigation is pending for investigation is pending for arrest of the other co-accused. But having heard the submission of learned advocates of both sides, I have gone to the petition and the documents placed on record, and also carries the case ID with the assistance of Mr. Sharma. No, Mr. Borua, learned additional PP. Case ID indicates that the IO has examined some witnesses and also released the seized kettle in the custody of Gusala. And the case is pending for arrest of the other co-accused persons. Further, it appears that the accused was arrested on 8/2/2024 and he is behind the bar for last 32 days. Thus balancing the period of detention with that of the nature and gravity of the offense and the punishment prescribed for the same, as well as the progress of investigation. Further custodial detention of the accused seems to be not warranted here in this case, and therefore this court is inclined to allow this petition. It's 50,000 or CJM Kamrupen.
And item 47 Lordship.
47 after some time.
My.
2024, the learned additional PP was directed to obtain a written instruction from the officer in charge Manikpur PS as to whether any case has been registered against the present applicant or not. Today, Mr. Sharma has produced one report from the officer in charge Manikpur PS. And submits that no case has been registered against the present applicant with the Manipur PS. Since no case has been registered against the present applicant, there is no apprehension of arrest, and as such, this application become infructuous, and accordingly the same stands closed.
Right. Time being item number 25.
The contraband which is recovered from me lordship is intermediate actually. And and lordship, I am.
Yeah, Barua, have you gone through that judgment?
Yes,
Yes,
my lord. He has cited two judgment Lordship. One is of the Honorable Apex Court Lordship. My lord, the Apex Court judgment, my lord, that is after, my lord, after conviction Lordship. At the stage of appeal, my lord, it was, my lord, it was decided that, my lord, that in paragraph 8. For example. So there was no evidence that also there was section 29 was there also, right? Abatement was there also. After evidence also. But in this case also investigation is there also. Section 29 is there.
So not in connection with granting bail.
Not in connection with granting. It is, my lord, after conviction also. After conviction when it was in the appellate stage. And other lordship, other judgment, it is from, my lord, Kerala High Court, my lord. In that case, lordship, there was charge sheet was submitted, but there was no section 29 lordship. It was only it was the total quantity was the commercial quantity, but it was recovered from three different persons lordship. But section 29 was not there in the charge sheet lordship. That is why lordship the honorable Apex honorable my lord Kerala High Court hold that lordship, since there was no section 29, my lord, and the quantity might have recovered from the three persons are, my lord, below commercial, my lord. So, my lord, section 37 will not apply. But in this case also, it is in the, my lord, investigation is there also, that section 29 is there. And, my lord, the contraband recovered from both the accused person, they were traveling together in a train also. Is pending for appeal.
Okay, we'll pass the order. You submit the judgments. Next item.
Item number 63.
My pleasure. Lordship, I searched but not found in your lordship. Service already completed, your lordship. There is a report, your lordship, in flag Z and Y, your lordship, of the record.
Pardon?
Service already completed, your lordship.
That's why one advocate has entered appearance on the other day. So if somebody appeared, then the service of notice is now immaterial.
One of let the matter become the after tomorrow showing the name of the advocate.
Not submit the Wakalatnama yet.
Name of the advocate is A. Rahman.
A. Rahman, it is mentioned in the last order also.
Yes.
So let his name may be shown in the process. Otherwise, it is a substitute case also when the matter speaks for, my lord, as per the last status report for the, my lord, consideration of search.
This is under section?
Under section, my lord, 354B, 376AB, 511, read with 12 of POXO.
Okay, day after tomorrow then.
Day after tomorrow. Only his name may be shown.
Mr. A.A.R. Karim, heard Mr. A.A.R. Karim, learned counsel for the accused, and also heard Mr. Jabarwa. Learned additional PP for the state respondent, non-appears for the respondent number 2. Though Mr. A. Rahman learned counsel entered appearance on 6/3/2024. List the matter on Wednesday,
13.
13.
May I pray for showing the name of the respondent number 2, Your Lordship, Advocate of Counsel in the court.
So Kalatnama has not yet been filed. Would it be proper to direct the registry to reflect his name?
Always.
So you try to contact him? Hmm.
Typing item number 64.
May I please, Your Lordship? My lord, this is a 439 application, my lord. The
Hmm.
matter was last listed on my lord 7th of,
After some time.
my lord. Here, my lord, 41 a notice was not served to the present petitioner.
Yes, on the other day, Mr. Lokor also informed that later on he was informed by the IO that it was not complied with. Well, let Mr. Lokor come. Wait for some time. We'll pass the order today.
My lord.
Next item.
Item number 30.
Case that he received.
May I please, Your Lordship? Lord, I submit your Lordship to the last order passed by this honorable court. Because based on the, my lord, IS submitted and the reply submitted by the present petitioner, my lord. On a pointed query, your Lordship was pleased to direct the, my lord, the IO to report to appraise this court as to whether pursuant to their application dated 23/11/2024, 23, whether any action was taken or not. So I do not know whether that after 21/2/2024, any entry is there in the diary. 21 to.
Yes, Borwa. The report of the IO is available.
No, report of the IO is not available also, but we have received the my lord case that he received.
Because on earlier occasion also, my lord, the IO said that there were materials. But based on the fact that the informant submitted one, my lord, IA, enclosing one complaint before the superintendent of police, my lord, Dhubri.
Where
So
is
this
Mr.
court was-
Mandal? Where?
My lord.
Mandal? On the other day, he appeared.
My lord. Today also, my lord, he was present, my lord. Prior to the break, my lord, he was also present before the circuit court.
Call Mandal, MA Mandal. Wait for some time.
Obliged.
Item number 40.
The accused petitioner is approaching your lordship for the second time by filing for 38 application, my lord. Operative portion of the FIR lordship will find at page 17, my lord. May I read out, my lord? In page 17.
Piece last time. So Khobiruddin is the informant.
My lord.
Kobiruddin is the informant.
It is the case of the daughter of the informant.
Yes, notice has been served upon him.
Yes, yes. Yes. On last application also,
So, Mr. Sharma, you received the case ID.
My lord, I received case diary, my lord, but my lord, after your lordship rejection, my lord, there is nothing, my lord, new.
there are, my lord, actually, I would like
Facts
to
remain same.
lordship's attention towards the operative portion of the FIR. wherein it
So, what
stated-
is the ground for filing this second
Because
application?
all the accused persons have been granted by a coordinate bench of this honorable court. Well, so I pray for parity on that ground. Because a similar set of evidence against all the persons involved in this case. Lordship will kindly peruse Annexure 3, my lord. Page 24. Paragraph 4, my lord.
So, you are the prime accused of this case.
Yes, my lord,
Yes,
not on same.
But
So,
the fact of the matter is the cause
you
of
are-
action to filing this FIR arose when I have denied to marry the daughter of the informant. But and that if your lordship would kindly peruse the contents of this FIR, there would not amount to any offense because whenever it was restrained by the other co-accused persons, that's why this FIR filed. If my family members would not restrain me to marry her, there was no question of filing this FIR. So entire cause of action set on criminal law has been set in motion against the present accused person only due to denial of marry with the advice of the co-accused persons at the relevant point of time. And on the other side, the informant is daughter of the informant is in touch with the present accused person also till this time. There is no further issue remain.
No, you are the prime accused here.
Prime accused, my lord, lordship may kindly go through the allegations first
The
of all.
case has been registered under section 376 to 313,
And the sections are no attracted in this case.
section 6 and 21 of the POCSO Act.
POCSO is not applicable, my lord, because whether the age of the victim is in question, and there is no delay has been explained while filing this FIR.
Hmm?
The delay is fatal in there are so
No,
many.
yeah, that's all right, but whether at the time of consideration of bail, this delay can be considered.
Yes, that's why prosecution may file appropriate report if there is any found guilty, but
No, no,
real
no.
interaction is no
No,
warranted.
that is a
Because-
matter of trial.
Yes, because before the IO, while granting interim by this honorable court during
Hmm.
pendency of my first application before your lordship, and I have deposed my version before the IO.
Hmm?
So custodial lordship may kindly peruse second annexure 2, my lord. Wherein it was recorded by this honorable court in paragraph 4, my lord.
Hmm.
Mr. Deka, learned counsel for the applicant submits that though the case is registered under section 621 of the POCSO Act, yet the sections are not attractive. Because at the time of filing of FIR, the age of the
No,
victim
that
was,
is the submission.
yes,
That is not the observation of this
no,
court.
no. That may not be, but I have appeared before IO in connection with this case, my lord, to depose my, because a person cannot be held to be guilty unless any he is held to be guilty by any competent court of law. So presumption of innocence always be in favor of the accused person, my lord.
Okay. Oh, what?
Presumption of innocence always be accused until and unless declared held guilty by any court of law.
That's all right. But
On that ground, I am ready
well,
to
there
face
is
trial
prima facie
or
material
cooperate with
against
the
you.
investigation, my lord.
Hmm?
I am ready to face any consequences with the cooperative in cooperation with the IO for.
Our age was 14 years.
But that aspect, there is no material to that effect.
Hmm.
What was happened in last 8 years ago. There is no material with the prosecution side. Only a except bold statement. There is no medical prescription earlier when pregnancy
No,
was.
you cannot submit on merit because on the other day we have produced the case ID and considered all aspect of the matter.
Because if
Now you were to show the sense of circumstance in your favor.
no, I
That's
would
all
like-
right. Some of the co-accused have already been granted bail by this court.
Yes,
But the question is whether you are in the same pedestal with those accused.
Okay, entire story, entire prosecution, this FIR was lost only for denial of.
No. You cannot submit on merit, Mr. Pal.
I may not submit, but I can rebut also, my lord, the allegations which has been leveled against.
No,
me.
not at this stage.
Then how?
We are to
lordship will-
consider the case diary and other materials available in the record.
Because material doesn't mean that a person cannot be
Yeah.
granted bail, my lord.
Because we have already considered that argument.
Yes, but material does not, though indicates my offense, but that is to be proved beyond reasonable doubt before the court of law.
No, not at this stage. Here, at this stage only prima facie materials. So except that ground, you have no other ground.
Yes, because my lord, entire FIR, I am repeatedly submit before your lordship that this FIR would not file if I would immediately marry that daughter of the informant at the relevant time before lodging of the FIR. So on that ground, by considering this aspect of the
No,
matter,
no,
all the accused persons have
that-
been granted bail
Sorry.
for cooperation of investigation.
Okay.
So on similar line, I pray for spirit.
Heard Mr. A. Pal, learned counsel for the applicant. And also heard Mr. B. Sharma, learned additional PP for the state respondent. This application under section 438 services prepared by applicant Netul Ali, who has been apprehending arrest in connection with Byatas Early PS case number 327 of 2023 under section 376(2), between bracket 1, stroke 313, stroke 506 IPC, dated with section 6, stroke 21 of the POCSO Act. This para number 3 of page number 21. Mr. Pal, learned counsel for the applicant, submits that this is the second application preferred by the applicant. And the first one, being AB number 3954 of 2023, was dismissed by this court by order dated 19/1/2024 after perusing the case ID. Mr. Pal further submits that the ground for filing this second application is that all other co-accused have already been enlarged on bail, enlarged on PRS bail by a coordinate bench of this court, and maintaining parity of the present applicant with the accused who have already been enlarged on bail, PRS bail. Mr. Pal contended to allow this petition. Whereas Mr. B. Sharma, learned additional PP, has produced the case diary before this court and submits that there is no progress in the investigation of this case since dismissal of the first anticipatory bail application by this court on 29/1/2024. And therefore, Mr. Sharma has opposed the petition. Para, having heard the submission of learned advocates of both the parties, I have carefully gone through the petition and the documents plus on record, and also perused the case diary with the assistance of Mr. Sharma, learned additional PP. It appears that by order dated 19/1/2024 in AB number 3954 of 2023, this court was placed to grant. No, this court was placed to dismiss the petition filed by the applicant. The only ground for filing this second application is that some of the co-accused have already been granted the privilege of PRS bail by the applicant, by a coordinate bench of this court.
On 30th November.
And that
30th November
the
20.
My lord, pardon, my lord, I have to leave till court, my lord, another court.
pardon?
I have to leave, my lord.
কি করলো last line তো? Double only ground for filing this second bail application, the second application is that some of the co-accused have already been granted bail, uh, and by a coordinate of this court. But having gone through the materials placed on record and also from the case study, this court finds that the applicant who has already been enlarged on PRS bail by a coordinate bench of this court by order dated 30/11/2023 in AB number 3749 of 2023. The present applicant is not stands in the same footing with the applicant of those anticipatory bail application, those PRS bail applications. And as such, parity cannot be maintained in respect of the present applicant with the applicant of AB number 3749 of 2023. The offenses are serious in nature, and case ID indicates sufficient materials against the present applicant, and the same has already been reflected in the order dated 19/1/2024. In view of above and also in view of the materials available in the case diary, this court is of the view that this is not a fit case where the privilege of PRS bail can be granted to the applicant, and accordingly the petition stands dismissed. Eta line eta logai dibo tate agole submission episode. It is to be noted here that notice was issued to the respondent number 2, and the same was served in view of office note dated 6/3/2024. But the respondent number 2 chooses not to appear before this court. Petition dismissed.
Time being item number 64.
Yes, Mr. Loskar.
Lordship, here in this case, on last occasion, though I submitted that 41A notice was complied with, but subsequently I heard that I got the information that from the IO concern that that has not been complied with. But even though Lordship, 41A notice was not served upon him, then also Lordship, he is not entitled for on that count, he is not entitled for bail, Lordship, because Lordship.
Why?
If you go by the judgment of the Ernest Kumar as well as Satyendra Kumar until Lordship, dear Lordship, Lordship, I have submitted that judgment, Lordship. In that judgment, Lordship, it is not stated that Lordship 41A notice is mandatory for any offences relating to 7 years or below 7 years, Lordship. Because 41A section 41A, Lordship, if you can go for the timing, Lordship, which says, Lordship, notice of appearance before the police officer. The police officer shall, in cases where the arrest of a person is not required.
Have you gone for the judgment of Satyendra Kumar until?
Lordship, that is the 100 para 100, Lordship. That is everything the last observation, Lordship. Here also, Lordship, 100.2, Lordship. It is also stated, Lordship. The investigating agencies and their officers are duly bound to comply with the mandate of section 41 and 41A of the code and the directions issued in this code in Ernest Kumar, Lordship. So, Lordship, neither in Ernest Kumar nor in Satyendra Kumar and until Lordship cases, it is not stated, Lordship. What I have understood, Lordship, subject to correction, Lordship. And that in
See,
each
this
and every case,
paragraph number 100.3.
Lordship.
There it is stated the court will have to satisfy themselves on the compliance of section 41 and 41A of the code. Any non-compliance would entitle the accused for grant of bail.
41 and 40. Then what does the 41A says, Lordship? 41A says, Lordship, that there is a special words, Lordship, where the arrest of a person is not required under the provisions of this section, Lordship. Section subsection 1, when the investigating authority or officer will not think, Lordship, that his arrest is not required, then he will submit, he will furnish the 41A notice. If he thinks that and that too, as per judgment of the Ernest Kumar, that too, that has to be.
No, what is your submission on this point? 103.
That is I'm submitting, Lordship, that 41A, 41A and 41 both has to be complied in each case, but wherever it is applicable. And in this case, Lordship, his 40 surplus 1 is applicable, Lordship. That has been complied with, Lordship. It is not stated, Lordship, that each and every cases where 7 years or say below 7 years punishment is required, then 41A is must be given. It is not stated, Lordship.
So in this
41A
case,
may be-
41A notice was not given to him.
Lordship, because police officer thinks that his arrest is required, that is why he has not given in.
Pardon?
Because police officer that investigating officer has his arrest is warranted, that is why he has not given that 41A notice. If his arrest is not warranted, then only he will serve the 41A notice. When his arrest is warranted, and that has been clearly mentioned that they have sent me the model checklist, Lordship, as per the mandate provision. Model checklist they have what they have annexed with the CD, Lordship, with the CS, Lordship, and CD. That is the mandatory, Lordship, regarding for fulfillment of for section 41. That is mandatory as per Ernest Kumar checklist.
So these are in respect of this.
So, Lordship, in Ernest Kumar, Lordship, it is also mentioned, Lordship, that is here, Lordship, in 11.2, Lordship. We cannot read only the 11.6. We have to read it from the 9, paragraph 9, 10, thereafter 11, Lordship. And 11 is the that is the observation and that is the guidelines. In guidelines, para 11, Lordship, may kindly pay that as husband I have given, Lordship. 11 number 1, 11.1. All the state governments to instruct the police officer not to automatically arrest when a case under section 498A IPC is registered, but to satisfy themselves regarding it is 498A. Thereafter, Lordship, 11.2. The police officers be provided with a checklist containing specified sub-clauses under section 41 1B2. That is when their police warranted the arrest. Thereafter, 11.3, the police officer shall forward the checklist duly filled and furnish the reasons and materials which necessitated the arrest while producing the accused before the magistrate for further detention. Thereafter, 11.4, the magistrate, while authorizing detention of the accused, shall peruse the report furnished by the police officer in terms aforesaid, and only after recording the satisfaction, the magistrate will authorize detention. 11.5, the decision not to arrest an accused be forwarded. That means, also this has come under 41A. The decision not to arrest an accused be forwarded to the magistrate within 2 weeks from the date of institution of the case, which a copy of the magistrate, which may be extended by the superintendent of police of the district for the reasons to be recorded in writing, if he is not arrested, Lordship. Then 11.6, notice of appearance in terms of section 41A CRPC be served on the accused within 2 weeks from the date of institution of the case, which may be extended by the superintendent of police of the district for the reasons to be recorded in writing. Here it is not said all in each and every cases, Lordship. where there is a 41A is applicable and 41. Thereafter, Lordship, failure to comply with the directions aforesaid shall, apart from rendering the police officers concerned liable for departmental action, they shall also be liable to be punished for contempt of court to be instituted before the High Court, having territorial jurisdiction. Here it is not stated that only the 11.6 has to be complied. Here it is said everything 41(1) has to be complied, 41A complied, wherever it is applicable. So Lordship, here in this case, Lordship, when there is a checklist where that has been complied with, and the police warranted, why he has been warranted with the arrest, that has been that has been described in the checklist, Lordship. Even in Antil Kumar's case, Lordship, that same has been reiterated, Lordship. So my submission is that, Lordship, and only because of non-furnishing of 40 notice to him may not be a ground for his granting bail, Lordship, because Lordship 41A is not
No,
applicable. In this case.
in paragraph number 103, it has been clearly stated any non-compliance would entitle the accused for grant of bail.
The court
Where
will
is
have
the
to
scope for
satisfy.
interpretation?
That is, Lordship, here also 41A is also here, 41 is also here, and 41A both. Where it is applicable, Lordship, to my understanding, if here in this case, if it is applicable for 41A, then it is 41A. Then when police warrant the actual language of the court, Lordship, that what is it says, Lordship. We cannot deny that court, Lordship, that, and that has not been touched by the Honorable Court, Lordship. The police officer shall, in all cases where arrest of a person is not required, under the provisions of subsections 1. Because entire 41 is for section 44, under entire section is for 7 years or below 7 years. 41 section is mainly issue notice. So Lordship, here in this case, Lordship, his arrest was warranted. That is why he has been arrested. And in that case, 41(1) is applicable, or 1B. 2 is applicable, and that is why that has been complied with as per Anis Kumar's husband, as well as the Antil Kumar Sharma's husband, Lordship. Otherwise, in each and every cases, everyone will come, Lordship, that 7 years punishment, it is 7 years punishment, and 41A has to be complied with. It is not stated in Anis Kumar's husband or Antil Kumar Sharma's husband.
Where is the one for the forwarding report?
My lord.
Page number?
Fine. At page number 18. Page 18, annex 3, my lord, forwarding. My lord, no explanation has been made by the IO, my lord, in the forwarding report. Why this 41 notice has not served to the present petitioner?
It is not stated, Lordship, that it is forwarding, in forwarding report, it is required, Lordship. That is a separate checklist is there, Lordship. And in CD, it is CDR, Lordship. That is the checklist mandate as per the Anis Kumar's judgment. That has been complied with. And that is a separate checklist, checklist has been prepared. Then why it is declared for?
No, that is only in respect of 41.
41.
What happened in respect of this 41A?
41A, Lordship, when the police do not want his custodial interrogation, then police will serve him a 41A notice, and thereafter he allowed him to come. And that too, he is in this. It is a strict rule because.
Okay, all right. We have taken note of your submission.
And one more thing, Lordship, I have talked with the IO, Lordship, IO concern, and he has informed me, Lordship, that, Lordship, here in this case, some serious allegations are there, Lordship. Though he could not furnish me the CD as it has already been searched there, Lordship. One Mr. Khalil Sheikh has been given 164 statement, wherein he has stated, Lordship, that because of because he could not give him the huge amount of interest amount. And for that, he has been brought to the Calcutta, and thereafter his one kidney has been sold out, Lordship. That is the major allegation in this case, Lordship. So Lordship may kindly call
Okay,
for the
you
city,
raise our
Lordship.
case and investigate the same. And if there is
Lordship,
material, you furnish search it.
because Lordship, and as per the here in this case, Lordship, what they have in their model checklist, Lordship, it is here it also it is their grounds stated, Lordship, that Lordship why his arrest is required and why whether he can hamper or temper the witnesses, Lordship. That is last, Lordship, the arrest person have been apprehended from Jogighopa while he was even when one person is tried to flee out. Then Lordship, how much and one person who can sell one person's kidney, Lordship, then how much he can influence that evidences, Lordship. So Lordship, everything can be revealed, Lordship. Lordship may kindly peruse the CD, Lordship. Thereafter, Lordship may take any decision, Lordship. My humble submission, Lordship.
Okay, heard, mister?
My lord, the lordship calling for the city, my lord.
Pardon?
If the lordship calling for the city, my lord, I have an objection, my lord, because the police has already searched it, my lord. And my lord, under section 354, and the present, my lord.
This mic.
My lord, the.
Mic.
Again, it's on, my. My lord, in this case, my lord, the search sheet has been filed, my lord, under section 384, my. My lord, in this case, my lord, already the search sheet has been filed, my lord, under section 384, my lord, of Indian Penal Code, my lord. And the present petitioner, my lord, is in custody, my lord, 24 days, my lord. And my lord, in the FIR, my lord, the informant, nowhere it is stated, my lord, that the extortion has been done to the present petitioner has extorted the informant, my lord. Nowhere he has stated in the FIR also, my lord. Everything he has stated in the FIR, he have all heard from someone, my lord.
Okay. Heard, mister?
TJ, hello.
Learned counsel for the accused and also heard, Mr. P.S. Locker, learned additional PP for the state response. This application under section 439 services prepared by accused Wasim Ahmed, who has been languishing in jail in connection with Abhayapuri case number 55 of 2024 under section 120B 420 406 T80 Pro IPC. Since
18.
Where do you have mentioned it?
My lord, first title, my lord, page 2.
Since 18 to 2024 for grant of bail. Is to be noted here that above noted case has been registered. The basis of one FIR lost by one. Deposit also on 16 to 2024. The sense of allegation made in the said FIR is that where is the FIR?
My lord, page 16, my lord, this is vernacular, and my lord.
That one Wasim Ahmed has been running money lending business for a long time. And he used to extort money from the poor people in the name of the said business. Then he enters into the houses of the people at night and collect interest and extort money by threatening them. And one young businessman from Bawali Mari committed suicide 3 years back on account of physical and mental torture subjected to him by the accused. And he used to extort 20 to 30% interest from the poor people by claiming that he has a license to collect interest. Mr. Halloy, learned counsel for the accused, submits that the accused was arrested on 18 to 2023 And for last 24 days, he has been languishing in jail hazard. Mr. Holloway further submits that while causing arrest of the accused, the IO has failed to comply with the provision of section 41A CRPC, and on account of failing to comply with the same, the accused is entitled to bail in view of the judgment of Honorable Supreme Court in the case of Satendra Kumar Antil versus CBI. And that the case has already been submitted. No, the IO has already completed investigation and submitted charge sheet. And the accused is ready to face trial, and therefore it is contended to allow the petition. On the other hand, Mr. P.S. Locker, learned additional PP, submits that he has not received the case diary, but as per his instruction, the IO has completed investigation and submitted charge sheet, being charge sheet number 55 of 2024, dated 29/2/2024, under section 384 IPC, read with section
12 lordship. It is section 12 of 10 giving.
read with section 12 of the
Lordship,
Assam Money Lenders Act 1968. Mr. Locker further submits that there are serious allegations against the present applicant, the present accused, and in the judgment of Ernest Kumar, nowhere it is stated about. Mr. Locker further submits that the IO has complied with the provision of section 41 of the CRPC while causing arrest of the accused. Arrest of the accused. And Mr. Locker was directed to obtain instruction from the IO concerned by the order dated 7/3/2024 as to whether section 41A of the CRPC was complied with at the time of causing arrest of the present accused or not. And accordingly, Mr. Locker, obtaining necessary instructions, submits that the said section was not complied with. It is to be noted here that in the case of Satendra Kumar Antil versus CBI, Honorable Supreme Court has, in paragraph number 100.3, stated that the court will have to satisfy themselves on the compliance of section 41 and 41A of the code. Full stop. Any non-compliance would entitle the accused for grant of bail. In the case in hand, admittedly, the aforesaid provision has not been complied with. Though Mr. Locker, learned additional PP, submits that service of notice under section 41 CRPC is not required, as the IO has satisfied and the IO has intended to cause arrest of the accused. Yet the said submission left this court unimpressed, in view of the fact that in no uncertain term, Honorable Supreme Court in Satendra Kumar Antil, in paragraph number 103, stated that any non-compliance would entitle the accused for grant of bail. Besides, it appears that the IO has already completed investigation and submitted charge sheet. Now trial will start, and the accused has also to prepare his defense. Under the aforesaid facts and circumstances, further custodial detention of the accused seems to be not warranted here in this case, and therefore this court is inclined to allow this petition. It is provided that on furnishing a bond of rupees 50,000 with one security like amount to the satisfaction of the learned judicial magistrate Gwalpara, the accused be enlarged in bail.
SDJM, not Salmara.
Not Gwalpara.
Not
Acha,
Gwalpara.
okay.
Not-
SDJM M Gwalpara.
Not Salmara.
No, sorry, not Salmara. Obhayapuri.
File your place.
Time being item 30.
My lord, there another item, my lord, for delivery of judgment, item 60, my lord. Supplement.
So that has been deferred.
My lord.
So this record is not available.
My lord. Highly appreciated.
May I release your lordship? Lordship, kindly pass over the matter for 10 minutes. No, for the day, lordship.
For that day. What is your name?
Al-Khatam.
Ms. So-and-so, learned counsel appearing on behalf of the respondent number 2. Press for listening the matter on Wednesday.
Except for PSD, I have some.
Thursday.
Of the 14 March. Time being item number 5.
Instruction.
My lord, I have tried to find out, my lord, collect the, my lord, 18 instruction, my lord, not received, my lord.
So tomorrow,
My lord, tomorrow, my lord. Tomorrow, my lord.
Mr. Sharma submits that the information required by the order dated 5/3/2024 could not be collected by him. Press for listing the matter tomorrow. They are allowed rest to do the needful in this regard.
All right.
Item number 41.
Notice issued upon respondent number 2 is served lordship and service report is awaited lordship.
Service awaited.
Awaited. Kindly give another lordship.
Office note dated 5/3/2024 indicates that step upon the respondent number 2 has already been taken. But no report has been received till date. Registrar leads the matter after 1 week, awaiting service report upon respondent number 2. You received the case there, Mr. Barwa?
My lord, we have not received the case there, lordship. My lord, scan copy was called for, lordship. The certificate case, lordship.
Scan copy.
Yes.
Which scan copy has already received?
May I pray for a date lordship?
Yes. When? Date.
22nd March.
Deeply obliged lordship.
Item number 42.
Should you was called for? Receive my. Prior page, my lord, acknowledge at page 18, my lord. Initially, it was lost before the court, my lord, and court shall need to register a case. Yes, suit petitioner, my lord.
Yes, Mr. Sharma, you received the case.
Yes, sir, my lord, I received. My lord, kindly 164 statement of the victim as well as the husband of the victim.
Yes, Mr. Monto.
My lord, this, your lordship kindly see this FI was lost after 26 days, my lord. There are 2 days of occurrence, your lordship kindly see. One is, my lord, in 22, November 22, and other is, my lord, 22/12/2023. And so far is, my lord, IT section as concerned, my lord, 66A. 66A is, my lord, it is no longer exist, my lord. That's the wrongly. And so far 67 is concerned, my lord. Your lordship kindly see 67, my lord, if it is a first offense, that is available. 67. And regarding, my lord, petitioner number 2, in the FIR, my lord, only one line, my lord, your lordship kindly see this very allegation against him, my lord. And so far 376 is concerned, my lord, their lordship kindly see they have a relationship with 2022, my lord. Along with, only with my respondent of petition number 1.
But the problem is that once he says that no, it is no. That is the law.
that's my lord, suppose my lord, your lordship kindly, my lord, see that she has clearly stated the relationship with 2022. Since 2022, my lord, they have a relation, my lord. So meaning there, my lord, is a consenting party, my lord.
No, at that time, but subsequently she was not a consenting party. You have recorded the video and thereafter, so
No, my
you
lord.
have blackmailed her.
No, my lord. Recording of video, what, my lord? Your lordship kindly see.
One Gayatri Banerjee, my lord. And Gayatri Banerjee earlier filed an FIR at page 19, my lord. The present FIR is dark number 642.
The secondary lordship, may kindly give 1 day time lordship, then I will try to bring it lordship. We have got to
It is
do
from
lordship.
Gitanagar.
Mr. Lokor, it is from Gitanagar PS.
It depends, lordship, sometimes
You-
Tahsil also we have not received.
Even from the Lotasil PS, which is less than 100 meters away from here, you take a week's time to produce the case.
And it is from materials available record, it can be decided, my lord, because in the FIR, it shows dark number 642. The one FIR which was filed by Sandeep Chorari.
Anyway, Mr. Khan,
Yes, my lord.
okay, wait for tomorrow.
Yes, my lord.
Let him avail the sons.
Yes, my lord.
Mr. P.S. Lokor, learned additional PP submits that he has not received the case diary and pays for granting 1 day time. Though in the order dated 4/3/2024, it has been reflected that in the event of failing to produce the case diary, the court will proceed to hear and dispose of the application. Yet, in view of the fear being made by Mr. Lokor, he is granted 1 day time. This is a least the matter tomorrow.
Item number 44.
Yes, Sharma received the case diary?
received, my lord. She did not.
Oh, what do they always they were saying that the CD not available. This is from Bosistop, yes, or Sonapur.
Sonapur, my lord. Sonapur, my lord.
So day after tomorrow?
My lord.
Mr. B. Sharma, learned additional PP submits that he has not received the case diary, and accordingly it is provided that Mr. Sharma shall produce the case diary before
My
the
lord.
court on day after tomorrow. In the
Okay.
event of failing to produce the case diary on that day, the court will proceed to hear and dispose of the application without case diary.
Item number
45.
out of the same FIR. Same.
45?
40.
Okay.
Same order.
Same order.
Same order.
Item number 46.
High evidence.
Particular petition was page 7, so the petitioners are the owners of the vehicle. Apparently, one cattle each were half of the vehicle.
Yes, Sharma CD available here.
CD receive, my lord. CD receive, my lord.
So is there any material?
My lord, material is there, my lord, against the present would the petitioner, my lord, on the statement of the my lord.
Heard Mr. A. Dekel, learned counsel for the applicants, and also heard Mr. B. Sharma, learned additional PP for the state respondent. Apprehending arrest in connection with Raha PS case number 4 of 2024 under section 379 IPC. This application under section 430H CPC is prepared by applicant Moidul Islam and Abdul Kadir for grant of PSP. The above noted case has been registered on the basis of one FIR lost by one Vikram Tati. Page 7 is the FIR
My lord.
on 11/1/2024. The essence of allegation made in the FIR dated so and so is that on 10/1/2023 at about 3 AM, one of the cow of the informant, namely Vikram Tati, was stolen in a car. Then he searched the car. but failed to intercept the same. Then with the help of some other person, he further searched the vehicle and found on Bolero, found on Baleno vehicle bearing registration number AA01 FK1690 standing at the railway crossing. And having searched the vehicle, he found his car kept in the dicky of the said vehicle, being tied with being tied with rope. Then being tied her legs with ropes. And having searched another vehicle standing there bearing registration number AS02 AM8775 and found another car. No, sorry, another cow inside the dicky. But some of the people of the cow could manage to escape due to darkness. Thereafter, they have reported the matter to Sapamo police station. Mr. Dekka, learned counsel for the applicant submits that the applicant are the owner of the
Yes,
vehicle.
yes, both the
Which vehicle? Both the vehicle.
both the
Both the vehicle. And that they are innocent and no way involved with the offense alleged in the FIR, and they are ready to cooperate with the investigating agency, and therefore it is contended to allow the petition. On the other hand, Mr. B. Sharma, learned additional PP, has produced the case jury before this court and submits that the IO has collected sufficient incriminating materials against the applicants, and therefore Mr. Sharma contended to dismiss the petition. Therefore, having heard the submission of learned advocates of both sides, I have gone through the petition and the documents placed on record and also perused the case diary with the assistance of Mr. Sharma, learned additional PP.
Wahidul Islam and Abdul Kader. Islam.
The case diary indicates that the IO has collected sufficient incriminating materials against both the accused, both the applicants. Investigation is going on and extending the privilege of Pira's bail at this stage will misdirect the investigation. Accordingly, petition stands dismissed. Case diary is open.
Item number 47.
Again, the petitioner is the owner of the
This is related with item number 26, Lordship. my lord, 15 cows were recovered from the vehicle, lordship. And the driver was detained, my lord, because he could not produce any document. Now, this person, my lord, he is the owner of the vehicle, lordship.
So is there any material against him?
Direct materials are not there because the driver has not implicated the owner. The driver has said, lordship, that some unknown person has, my lord, loaded the, my lord, cattle in his vehicle, but they have not produced any, my lord, supplied any documents.
Polita. 26 item to kone losil. 47. Okay.
Item number 48. At least lordship. My lord, this is a pre-arrest bail application. My lord, FIR at page 11. Petitioner before your lordship is not, my lord, named accused. He is, my lord, driver of this alleged vehicle, my lord.
The petitioner is the driver of the vehicle.
No, my lord, owner of the vehicle, my lord, and he got, my lord, the of this vehicle by, my lord, as per report, page 12, annexure 2. It was furnished by the, my lord, concerned investigating officer. This, that, my lord, the Jahirul Islam Borbuya is the owner of the vehicle, and considering this report, my lord, by order, page 14, my lord, this vehicle was given Jimma to the petitioner, my lord, and it was provided.
But how the betel nuts came to be loaded in your
My lord,
vehicle?
this is, my lord, as per the, my lord, statement, he has categorically stated that, my lord, this is local, my lord, betel nut, my lord, but police suspected, my lord, this big size, my lord, betel nut, my lord, and police suspected, my lord, this may be, my lord, stolen from foreign country.
Yes,
my
sir.
lord.
Local, you received the case daily?
Lordship.
Whether any report is obtained in respect of about the origin of the betel nut?
Lordship, here it is a report, lordship, that it seems to be non-local origin, lordship.
As per report.
And if he is admitted that, lordship, it is a local and they themselves has loaded it, lordship, then, lordship, he is involved in this business, lordship.
He is, my lord, owner of the vehicle.
He is the owner.
And, my lord, there is no source, my lord, suspected, my lord, 379, also there, my lord. And this is
Maybe,
big-
but as per report, those were non-local origin.
My lord, this is their suspicion, my lord. Nowadays, my lord, I have personally
No,
also
no,
been,
no,
my
no,
lord,
no, no.
Not the suspicion. This is food analysis report, lordship. This is from the.
Nowadays, my lord, hybrid betel nuts are, my lord, also grown up in the locality, my lord, everywhere, my lord. Only, my lord, he is.
That is your defense case.
Yes, my lord, owner of the, my lord, vehicle, my lord, cooperate, my lord, and Jimma is also given to him, my lord, of the vehicle, my lord. And nobody has, my
Oh,
lord,
what is the stage of investigation?
Lordship, only 2 or 3 witnesses has been examined, lordship, but it is under very premature stage, lordship. And where from he has got, it is to be ascertained, lordship, only from his custody interrogation, lordship, because this is not a lordship, that it is 2,000 kg more than lordship. Lordship, altogether, lordship, it is 2,672 kg, lordship. It's a huge quantity, lordship.
and my lord, nowadays,
And
my
they
lord,
have admitted, lordship. Now only lordship, that is, they have brought it, lordship. So, lordship, if they have brought it, lordship, then how from, where from they have brought it, lordship? Is to be ascertained, lordship.
only, my lord, there, my lord, he is the owner, my lord. In the FIR also, my lord, they claim, my lord, from another state, my lord. And nobody has claimed the ownership of the betel nut, my lord. Only on suspicion, my lord, they caught this vehicle, my lord. Petitioner before your lordship is the owner. And, my lord, Jimma was also granted by the learned trial court, my lord.
Giving Jimma of the vehicle, that is different matter, lordship. He is the owner of the vehicle.
My lord,
that is not a
lordship,
disputed
kindly have a look. I have
lordship.
stated, my lord, in the paragraph 4, my lord.
No, maybe that is your defense case.
Only, my lord, nobody has, my lord, claim ownership of the vehicle, this betel nut, my lord.
No,
Only on
maybe
suspicion.
in order to ascertain that aspect, some time has to be given
My
to
lord,
the.
even, my lord, assuming, my lord, this is, my lord, from foreign origin, my lord. This is the case of, my lord, my lord, another department, my lord.
Means?
My lord, this is, if it is, my lord, it is a origin, my lord. Then this is the, my lord, department, excise department, my lord. The police ought to have, my lord, given this information to the excise department, my lord. Then excise department would have, my lord, determined this, all this aspect, my lord. But they have registered this case, my lord, under 379, my lord. So ownership, my lord, there should be owner claiming that this is stolen property, my lord. And they have, my lord, on suspicion, and in the FIR itself also, my lord, they have stated that they have brought this from another state, my lord.
In that case, lordship, no one
And your
can, no
lordship
police
granted, my
can
lord,
arrest any person, lordship. No one police can any person. In fact, in NDPS case also, lordship. Because this is no one can has lost any FIR, lordship. That this is my material has been stolen, lordship. My illegal material has been stolen, lordship.
And this kind of, my lord, settlement is, my lord, well grown in the, my lord, hilly area of, my lord, this Miju, my lord, hill side, my lord, and, my lord, Katli Chola, then Garmura, my lord, this is hybrid.
Mr. Barbuya, in view of the report of that food analyst, it is of non-local origin. Then where is your case?
My lord, this petitioner before your lordship is the driver, or owner of the vehicle, my lord.
Maybe, but can it be said that while Udayoti or connivance, the driver has loaded
Yes, my lord,
non-origin,
no, my lord,
non-local origin metal nut in the vehicle?
yes, my lord, no past, my lord, any criminal background, my lord.
No.
No, my lord, I will file, my lord, one affidavit, my lord, who was the driver, my lord, in this case, my lord, and who was on
Admitting
that
his
day.
guilt, lordship. He's admitting that, lordship, from the very beginning of the today's submission, lordship. That is legal.
My lord,
Not
my
illegal,
lord,
lordship.
reality is that, my lord, this.
Okay, you file an affidavit, then we will see.
Yes, my lord.
Mr. N. Barbuya, learned counsel for the applicant submits that he may be granted some time to file an additional affidavit so as to bring on record some relevant documents there is allowed. List the matter on when?
Next week, my lord.
Next week. Till then, case there will be retained.
22nd March.
22nd.
Item number 49 for orders.
Let's say kindly peruse the last order, by which your lordship was used to ask learned PP to obtain instructions regarding the service of notice lordship.
Mr. Locker, have you obtained any report?
I have no DC person. I have not DC person.
This I is pending for quite a long time. So Mr. Locker learned additional PP submits that he could not obtain the report as required by this court by order dated 9/10/2023 and 28/2/2023. 4. Accordingly, it is provided that register list the matter on when
18 March. 18 March.
so as to enable Mr. Locker to obtain the report as required by order dated so and so so and so.
Lordship, council has some difficulty, so it can be 90. Council has some difficulty also.
When?
19.
19.
Okay.
Item number 50.
Yes, sir. Lord, as per inspection, my lord, the petitioner is not willing to freeze that case. So, my lord, this matter may be taken from not test, my lord.
Pardon?
From not test, my lord.
They are not willing to praise this method.
My lord,
They are not willing to praise this method also. Petitioner
Acha.
petitioner is not willing to praise that matter.
You want to withdraw this petition?
My lord.
Mr. Jai Islam, learned counsel for the petitioner submits that he has instruction to withdraw this petition accordingly. Prayer is allowed. There's a criminal revision petition, instance dispose of on withdrawal. Liberty will be required.
My lord,
Liberty
with liberty.
with liberty. However, liberty will remain with the petitioner to approach this court again by filing a appropriate petition.
Question number 51.
Your Lordship, as per Office Note 6324, the service upon respondent number 1 and 2 is incomplete, Your Lordship.
So notice could not be served.
Because address was wrong as per the office.
Report of what to do?
Lordship, I may be permitted for take fresh steps.
Okay. Office note dated 6/3/2024 indicates that service notice upon respondent number 1 and 2 could not be served. As addressee not found. The learned counsel for the petitioner submits that she may be permitted to take fresh step upon respondent number 1 and 2 by obtaining their correct address. Where is accordingly allowed, registrar list the matter on
27 March.
step be taken upon respondent number 1 and 2 within 2 days from today by registered post and also by usual process.
Short lecture.
Doing consideration for the IML for suspension of the sentence. The allegation is under POCSO. So therefore, the information will be required. Notice may go.
Convicted under section?
Under section 5.
Five.
I'm sorry, section 8 of the POCSO.
Section 8.
8 of the POCSO.